Thank you. I'm going to turn over the panel discussion over to Kim Whaley. Kim's a founding partner of Whaley Estate Litigation. We all know Kim. She's a certified specialist in estates and trusts. She's a leading practitioner and expert and many other reviews. She's the immediate past chair of the CBA Elder Law section and an adjunct professor at U of T, Queens, and Western.
Our next advisors, Jeff, Arthur, and Sue, will discuss accounting, tax, and variation issues relevant to the Phillips family and their current wants and needs. We'll start with Jeff Berliner, who's a founding partner of Cummings, Cooper, Schuschein, Berliner, and his practice encompasses personal and corporate tax planning, reorganizations, preparation of wills and trusts, implementing estate freezes, divisive reorganizations, and establishing private family foundations for charitable giving. Following Jeff will be Arthur. Arthur is a partner at the Borden Ladner Gervais Toronto office in the tax group. Arthur's primary areas of practice include advising financial institutions on issues related to aging and vulnerable investors, advising commercial fiduciaries on issues of mental capacity and estate law, the creation of corporate commercial trusts and charities, as well as estate planning and administration. And lastly, but not least, will be Susan Stamm, who joined the Office of the Children's Lawyer in 2007 in the Property Rights Department. Susan practices exclusively in the area of estate and trust litigation, as well as following estate administration on behalf of minors. Sue is an experienced litigator in all aspects of estates and trust law. So without further ado, Jeff, over to you.
Thanks, Kim. So when Charles first approached me, he said, well, I'd like you to do something about why it's not a good idea for the settlor to be a beneficiary. Well, that would have taken about 32 seconds to answer. So I got a little bit more expansive, and I'm going to deal with sort of the tax issues for trusts, things that I see coming across my desk that may or may not apply specifically to the fact situation, but hopefully it's things that you can take away and say, yeah, that does arise from time to time. So in my practice, normally when we're doing an inter vivos family trust, we're looking at it and saying, okay, what do we hope to achieve? Well, most times we're looking at some form of creditor protection or income splitting. Income splitting with private corporations has sort of been curtailed quite a bit by the new tax on split income or TOSI rules, but we've still got the ability to multiply capital gains exemptions. So the, quote, normal rules for tax that you hope to achieve with a family trust are, well, if income is taxed in the trust, it's taxed at the top tax rate applicable to individuals, but the trust can allocate income out to beneficiaries, in which case the income would be taxed in the hands of the beneficiary. 75-2, which you've heard mentioned several times, is clearly a provision that we want to stay away from, because if 75-2 applies, then you don't get any of the tax benefits. Whoever the transferor or the settlor is of the property gets stuck with all of the income and all of the gains that would be realized by the trust. So no capital gains exemptions being able to be multiplied, no income able to be split. So 75-2 really applies in three situations. We've heard the one situation mentioned and applies to the case where the property can revert back to the settlor. There's two other situations, though, where 75-2 can apply. One is if the property can pass to persons determined by the settlor, or number two is if the property can't be disposed of without the consent of the settlor during the settlor's lifetime. So we look at three different situations. So if the settlor is a beneficiary, then obviously the property can revert back to the settlor, and therefore 75-2 applies. 75-2 would also apply if the settlor is the sole trustee. It would be very difficult to say that the property, that the settlor doesn't have the ability to determine where the property goes if he or she is the sole trustee. What about if the settlor is one of two trustees? And I've seen trusts where we have two trustees. Well, on the one hand, you'd say, well, if you have two trustees, then decisions have to be unanimous, and therefore the property can't be disposed of without the consent of the settlor, in which case 75-2 would apply. CRA has said that, well, depending upon the facts and circumstances of the case, 75-2 may or may not apply. The argument would be, presumably, that the settlor acting in his or her capacity as trustee is not the same person or has an obligation to act not in their own self-interest, and therefore it wouldn't apply. From my standpoint, I wouldn't want to have to rely upon the graciousness of CRA to say that in the situation where you're one of two trustees, that 75-2 doesn't apply. Now, the word revert is actually interesting. And sometimes as lawyers, we like to get too wordy. You'll see in agreements, that this applies notwithstanding the foregoing, or, notwithstanding the generality of the foregoing, blah, 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 blah. Well, what happens in a trust where there are no longer any beneficiaries? So let's say you do a family trust and the beneficiaries are John, Jim, and John and Jim's issue. Well, if everyone dies, the trust in effect fails because there are no longer any beneficiaries. And under law, the property would then revert back to the settlor. And CRA has stated that if the trust fails, that is not a situation that was really contemplated, and 75-2 would not apply. However, if the trust deed says, and if there are no longer any beneficiaries of the trust alive, the property of the trust will be divided as determined by the settlor or the settlor's will if the settlor is not alive. In that situation, even though we get to the exact same result, it goes back to the settlor or to the settlor's will, CRA has said you've contemplated that at the beginning, at the outset of the trust, and they will apply 75-2. And that's an interpretation that goes well back. The circumstance, now, when a trust terminates, or the property is disposed of, but every 21 years there is a deemed sale at fair market value of all of the trust property. The way around the deemed sale at fair value is to distribute the property to Canadian residents before the 21st anniversary, and that generally occurs on a tax-free or a rollover basis. However, subsection 107.4.1 provides that if at any time during the life of the trust 75-2 applied, then the only person that can receive the property on a rollout basis is the settlor if the settlor is alive. So if the settlor is alive, the 21st anniversary comes, and 75-2 had applied, then it's a deemed sale at fair value if it goes to any other beneficiary. Now, 107.4.1 provides if 75-2 applied. You never even had to have income for 75-2 to have applied. So for example, if you had property go into the trust and the settlor is a beneficiary of the trust, and there was never income generated by that property, you invested in a stock that never paid dividends, but had gone through the roof. Even though there was no income actually attributed, because 75-2 applied, 107.4.1 would prevent the tax-free rollout to a beneficiary other than the settlor. So with those two rules in sort of being considered, here's something that sort of keeps me up at night. There's a lot of trusts out there. We set up trusts, we haven't set up trusts. A client now comes to you and says, the 21-year rule is coming up. I want to wind up the trust. You had nothing to do with the setup of the trust. And I look at the trust deed, and this has happened several times even in the last 6 months. I look at the trust deed, and my first question is, who's the settlor? And you say, oh, that's my accountant, or it's my financial advisor. Or the worst one that I had was, oh, it's my financial advisor's partner. The question becomes, who is the settlor? Is that person whose name is on the trust document actually the settlor? Remember, going back to one of the certainties is certainty of intention, and I take it a step further, an intention to make a gift to or for the benefit of the beneficiaries. I like most of my clients. I'm not sure I really have an intention to make a gift to my client or an intention to make a gift to my client's spouse or my client's kids who I may never have met. So now you have a situation where you're presented with this fact situation. What do? Do you go and say, okay, I'm going to just, ignore that. It says he's the settlor, you're a beneficiary, we'll wind up the trust, not a problem. Or do you have an obligation to inquire further? And I think you've got an obligation to inquire further, because this whole settlor of convenience, I think, opens it up to the situation where your client may in fact be the settlor, and this settlor of convenience may be the nominee or the agent of your client, in which case are we into 75-2? And if you don't do that, then does someone else's problem from 20 years ago, having set up the trust this way, become your problem if you proceed to wind up the trust and CRA comes in and says, oh no, John Smith was not really the settlor, your client was the settlor, and you're now into 107.4.1. And CRA, I think, is getting smarter on these. Just by a show of hands, how many of you have had clients that have had trust audits? A couple. So when you get that first questionnaire on a trust audit, they're saying, who's the settlor? What's the settlor's address? What's the relationship of the settlor to the trustee and to the beneficiaries? And in one I had, they actually wanted to interview the settlor. So in choosing the settlor, the questions that I usually ask myself are, is this person someone who would logically make a gift to my client and my client's kids? So parents, grandparents, aunts, uncles, maybe good friends. And it would be really nice if the settlor was interviewed and you could say, yeah, I used to, I was invited to the bar mitzvah or bat mitzvah of my good friend, and I did give a gift at that time. So that this isn't the only time where the person is making a gift. And I think that that's a real concern. And as trusts are maturing, I think we're going to be looking at that situation more and more in the future, and just something to be aware of.
Arthur, would you like to start?
So now that Jeff has given all of us a bunch of stuff to worry about, let me offer some comic relief by taking you through things that a couple of fictitious people should have been a whole lot worried about at a much earlier point in time. So I'm batting cleanup here, and you've had little snippets of tax reaction to what went wrong in the creation of the trust. At the risk of being a little repetitious, let me see if I can tie it all together for you a bit. There's a fundamental problem, and I think Peter touched on it in the way that the trust was set up. And in many situations where trusts have gone wrong, in the sense that they fail to meet the human or family objectives that they were intended to serve, it's because the order of values in creating them was reversed. People focused on technical issues where they should have stayed resolutely focused on the human objectives that the technical structure was meant to serve. And you've just heard an example of a very good practitioner taking exactly the correct approach, which was Peter in offering his advice to Brad just a few minutes ago. So let's start by focusing resolutely on what the human objectives here were that should have driven the entire process. The first and the dominant one was we had a young man who was saying, there's too much money here and I don't want to have to think about money management. Not, I'm looking to minimize my tax liability. Not, I'm looking to plan for minimizing, delaying, or avoiding tax liability in the future, but I'm doing other things with my life and I don't want to have to focus on managing my money. A reaction very common, by the way, for creative people, and one that often comes back to bite them, just as this scenario has come back to bite Brad. But a simple objective: manage the money without me having to think about it a whole lot. The second objective, which does have more of a tax spin, was setting things up to adequately meet the needs of a disabled person, Giselle, who we're told was never going to be financially independent of her parents. So, manage money, look after a disabled person. When you approach the problem with those two objectives in mind, you end up with a quick response, which is, this trust should never have been established. It was overkill in terms of what Brad required. It was underkill in terms of what Giselle required, because there are actually planning opportunities for her that, with all the focus on technical matters, were missed. So let me take you through those two things, but I want to, and this is following on something that Jeff said about the trust audits, because I would say, as a general rule, when I first started to practice in the area, the CRA would regularly bring esoteric challenges on issues of estate or trust taxation, and they lost the majority of them. Starting about 10 years or so ago, they started to focus more on whether or not there had been adequate and proper compliance in creating the structure in the first place, and they started to win regularly.
Yeah, they want to see they want to see the settlement property. They want to see the transition of did the settlor actually buy the property?
Exactly, and so you can no longer separate conceptually the substantive issues of trust law that go into creating a structure and adequate tax compliance. So, and we've sat here this morning and we're listening to competent professionals say, I'm not sure this trust was properly brought into existence. So by failing to keep focus on the human issues, including it was Brad's money and it should have been Brad driving the bus, you've ended up with a structure that at a very fundamental level may have failed to achieve its objectives. So the starting point here should have been Brad required independent legal advice on the creation of the structure. And the failure to provide it left Brad with a structure that might not achieve the tax objectives that he had intended to, or assuming that he actually wanted to protect Giselle, adequately protect her. Because if the trust is busted, whatever interest she has in it is defeated. So looking at, again, now let me focus first on Brad and then on Giselle's interests. Looking at it from Brad's perspective, I've already staked out a pretty clear position, which is this trust just never should have been brought into existence. It was overkill in terms of what he required. And in my mode as cleanup hitter, let me just summarize the problems with creating it. You've heard there was probably a taxable disposition when the assets were transferred in. That may be statute bars, so the CRA cannot do anything about it, maybe not. And even they may have a different opinion, which means you end up fighting about the issue, even if you're right. You've lost the ability to make tax-free rollout distributions to anyone but Brad. You don't have the ability to make them if Brad is no longer a Canadian resident. And that is something that we should all foresee when we're dealing with highly intelligent, ambitious people who are pursuing professional education. A lot of them end up living in the United States, so it's a reasonable thing to be concerned about on the way into a trust. You've already heard that the trust is tainted for purposes of Section 75, Sub 2 of the Income Tax Act. I won't belabor that point. In terms of technical planning, income splitting should not have been the dominant concern here. avoiding the realization of taxable gains over time unnecessarily should have been. But the truth is, because of the way the trust is set up, any opportunity for income splitting has been lost, and there are going to be difficulties, and there's exposure to premature realization of taxable gains. And two related points. By settling the trust for an 18-year-old, you started the clock ticking on a 21-year deemed realization of the trust assets. So at its 21st anniversary, in essence, the Income Tax Act requires the trustees to pretend that they'd sold their assets, and the trust becomes liable for gains. Now, we've heard that may not be an issue because there's so many losses locked up inside the trust, but if you take a look at the fact pattern, because of the way the trust was settled, it's not clear that you could get appreciated capital assets out of the trust prior to its 21st anniversary if you needed to. What were the alternatives? The first you've already heard from Peter, and he's clearly right about that. You could have just funded the trust with a loan from Brad bearing interest at the prescribed rate. That would have solved the problem, but in my view, that would simply have been a reasonably good way of doing an unreasonably bad thing. There's other things you could have done. Deb Stevens touched on this. You could simply have set up a discretionary trading account and made a practical arrangement so that the father would either monitor or provide instructions on the account. Brad is 18. It's the year 2000, which means the Substitute Decisions Act is in place. He could have granted a simple continuing power of attorney for property to one or both of his parents, which would have put them in a position to manage his investments for him, essentially with no tax consequences. And the final thing they could have done, if you wanted to get really sophisticated about it, was create a corporation as a holding structure. So if you were really worried, say, that Brad might all of a sudden wake up, realize how much money he's got, lose his heretofore sterling character, and decide to blow it all, you could put up a slightly more durable barrier between him and his assets, and you could either have rolled the existing assets in under the Income Tax Act, realizing no tax liability at all, or lent them to the corporation. So there were lots of planning options here that should have been considered. I want to focus on Giselle as well, in part because she's in the scenario, and in part because Peter Wiseman is here. Peter's work, professional activities have been widely and justifiably acknowledged in many settings. His work as an advocate for people with disabilities and advancing standards of tax planning for them has been unacknowledged. So as a kind of homage, let me dwell on this point. There are two fundamental concerns that should be considered anytime you're thinking of settling an inter vivos or a testamentary trust to benefit a disabled person. We're not told whether Giselle qualifies for the so-called disability amount, more commonly known as the disability tax credit, but if she is, that would mean a proper trust for her would qualify for something called a preferred beneficiary election. So that's the ultimate tax have your cake and eat it too, because you get to pretend that the income is hers for tax purposes while actually retaining it in the trust. Let's assume that she does. So if you start with that, you'd say, okay, unlike Brad, where tax is not or ought not to be a dominant consideration in terms of providing for the lifetime needs of a disabled person, you ought always to factor tax planning in, if only to ensure that you're making the best possible use of the available assets and maximizing the amount available to look after her. Second major factor is mental capacity. And here I want to take this opportunity to preach to the choir. I hope I'm preaching to the choir a little bit. There's a knee-jerk reaction. Disabled person, therefore trust, therefore Henson trust, without further analysis. All we're told is that Giselle has a disability that's going to prevent her from earning a living. We're also told that at some point a house was transferred to her name alone. There's no indication at all that she lacks mental capacity and is unable to play a meaningful role in managing her own assets. And there's a disadvantage in having your assets tied up in a trust that someone else manages. So that here, in her case, you're going to factor to, or ought to be, considering both the tax and financial aspects, but also the personal implications of a person who starts out with some disadvantages in life, who's now set up so that she'll never be in a position to play a meaningful role in the administration of her own assets. So we've looked at it. We've decided, yeah, we should be considering the use of a trust for Giselle. What would we say to the family at that point? Well, the first and obvious thing would be, let's make sure this trust isn't subject to Section 75 sub 2 of the Income Tax Act, so that if there is an income splitting opportunity with Giselle, we can take full advantage. Second thing we'd ask, what level of income does she require? I regularly see trusts for disabled persons that are way overfunded, which ends up creating both tax and administrative problems over time. There appears to have been a kind of knee-jerk here that says, well, she's disabled, she's dependent, so we'll give her an interest in 20% of $300 million. And there doesn't seem to have been any analysis of what she actually required. So, I mean, thinking of it practically, and given what the Ontario Disability Support Program pays out to people, if Brad had been willing to set aside, say, 1 or 2 of his $300 million in a separate trust for Giselle, that it's reasonable to expect that would have been enough to more than replace, leave her with a better quality of life than ODSP was going to, while freeing the family from the onerous, the loss of privacy and sometimes dignity that comes with being a recipient of benefits from the Ontario Disability Support Program. So maintain ODSP if you need to, but with this level of wealth, unless there's something special in what she's getting from the ODSP program, the planning should have been, let's just cut her off anyhow. If you did need to maintain ODSP, this is not the trust you would have used. Given what we're told about the trust, that Brad's consent was required for any payments to his sister, you might still have an argument that she didn't lose her entitlement to ODSP. So I want to take a hard stand on that. But if your primary objective was to maintain her ODSP status, then you would have used the so-called Henson Trust. Now, the other thing, and this is my final point, and this is a takeaway, I hope, Henson Trusts are awful. They say exactly the opposite of what they should say, because what you really want to say when you've got a vulnerable disabled person is you look after this person as though they were you or as though they were your own child. And in fact, what you're forced to say for technical planning reasons is they get only what you decide to give them, and you've got as broad a discretion as the law will allow you to have in deciding what they get, and you can take account of the amounts you distribute on the pittance that's received from the Ontario Disability Support Program. If it were not for ODSP, and if it were not for the fact that many families can't afford to plan for the long-term protection of disabled children without maintaining it, we would never use Henson Trusts. So if you can avoid using them, you should. And the alternative, if you must have a trust, is to put one together for Giselle that would have said something like, use the assets of this trust in the manner of a loving and generous parent.
Thank you, Arthur. Sue, I know there's only 2 years left with this trust, and so it's not likely a wise decision to vary the trust, but I know you have some comments on the variation and the response by the children's lawyer, and if you could share those with us.
Sure. The children's lawyer has to be served with any application to what's been described as a bust of the trust. So if a trust even has contingent beneficiaries who are either minor or unborn or unascertained, our office has to be served on their behalf. And that's because you can't just bust a trust. You can bust a trust if all of the beneficiaries are adults, but if the trust provides that beneficiaries, in this case, are as determined in his will, and his will provides that the beneficiaries are his wife, and if she predeceases his children, it would probably say their issue and equal share per stirpes, which would bring in an unborn class of beneficiaries because one doesn't know when he's going to die. So in the rare event that somebody decided they're going to bust open this trust 2 years before it's supposed to pay out to its beneficiary, that variation application would have to be served on our office. I've included a paper, it's at tab 10 of your materials, which talks a little bit about how our office looks at and analyzes variation of trust requests. And essentially what we have to do is we have to make a good bargain on behalf of the beneficial interest that we are, by statute, protecting. So in a circumstance like this, where the minor children are the unlikely contingent beneficiaries of a trust, so the most likely scenario would be that okay, all right, is that better? I'm reasonably loud, but that's a lot louder. So in the unlikely scenario, so the likely scenario would be that the named beneficiary is going to receive his funds because it's 2 years hence and he's a young adult. The next likely scenario would be that he gets hit by a bus and his wife receives the funds because she is an adult. But the unlikely scenario would be that she gets involved in some kind of an incident or a health problem and the children receive the funds. So we look at those children as unlikely capital beneficiaries. So what we're going to look for those children is a good outcome. And the good outcome would be a certain inheritance, something they're not likely to get if the trust played out. And so we would ask for a percentage of the trust to be paid into court to the accountant of the Superior Court of Justice to be held for those children until the vesting date in the trust. And on that vesting date, those funds would then be paid out to the deceased's issue in equal shares per stirpe. So if the minor children live till that date, those funds would become the funds of those children. So that's how we would look at this type of scenario. Now, in a circumstance where the minor children are the likely capital beneficiaries of the estate, we're often sent variation requests where, for example, the named beneficiary is only entitled to income during his lifetime, and the capital is actually supposed to go to the next generation. And he's saying, well, no, I'd like to receive all of it now. We would look at that and say, well, you're actually not entitled to any of the capital, and that would be a terrible bargain for those minor, his issue. So we wouldn't agree to it. In some cases, there's discretion to the trustees to pay out capital for him during his lifetime. And in those cases, we would look carefully at the wording of the will or the trust to determine the intention. So is this an intention ultimately to pay him out all of the capital during his lifetime, or is this an intention to create some kind of a dynastic passing of the interest to the children? And in those cases, we would look at the specific wording of the trust. But in a case like this, we would likely agree to a variation because these children would be unlikely to inherit in the ordinary course.
And Sue, what would happen if the children's lawyer were served with a statement of claim?
Okay. So in an inter vivos trust, while all the other professionals would have had lots and lots of involvement in this trust, the children's lawyer, and in fact no body of government, is required to be advised of an inter vivos trust, even if it's established for a minor. So even if this child were a minor when the trust was established, we would still not receive any notice. An inter vivos trust is an entirely private document, and the only time that we would know about it is if somebody tips us off and says, hey, someone's stealing from a child, or there is litigation involving it. We would be advised of it. We open a file, we do a cross-reference to see, hey, has this family come up before us? And it could be through other estates. We may have some cross-references. We'll check that. But largely in an inter vivos trust, we know nothing. So the first thing you'll probably get from us is, if it's a statement of claim, unlike an application record, there's no documents. And we would look at this and say, okay, could you send us the trust? We'd look at the trust and whatever other documents are referred to in the claim, and then try and figure out what our interest is. We might also ask for a family tree. So when you're serving us with something that we probably don't know anything about, anticipate that's what you're going to get from us. Who are these people, and who are we being served on behalf of? It's nice of you to tell us. It saves us a little bit of time, and it saves you the work of having to figure that out after the fact. And then we would look at it and we would analyze what our interest is. And in a case like this, where, as I've said, our interest is an unlikely contingency, we would probably do anything we could not to get deeply involved in this level of litigation. It will already be expensive. Adding our office, because we don't work for free either. We get paid out of the estate or trust, or we seek our costs out of the estate or trust in the ordinary course. Just adds another layer of legal expense. So if we're of the view that there's nothing we can add to this litigation, we will do what we can to take the lightest touch possible on the trust. In some cases, we might file what's called a statement of submission of rights, and that provides us with very limited rights in the litigation, which would be if, for example, the parties come to a settlement, we would be asked to consent to that settlement. We would also be advised, if the matter went to trial, of the trial date. And beyond that, we would have no interest. We couldn't claim costs. So that's something we might do. Alternatively, we might do nothing. We might send out a letter, and the letter would simply say, we're not getting involved. You can give this letter to the court. But in the event that anyone requests a variation, in this case likely a busting of the trust, in a settlement, to please let us know, and we'll reopen our file. And that would put anyone on notice to say that if there is going to be a variation and a wipeout of the interests of the minor or unborn beneficiaries, we should be advised. So that would likely be where we would fall on it. Now, if the facts were different and those children were the likely capital beneficiaries of this trust, and these allegations of incredible wastage of trust assets were put before us, we would get deeply involved in the litigation. We may retain outside counsel. We may need a forensic accounting, and we would get involved just like any other deeply involved beneficiary might.
Thank you, Sue. I think Jeff and Arthur and Sue have really canvassed the issues, identified the problems, and obviously given some good advice on the alternatives both from the outset and how to deal with the matter now in terms of the Phillips family. I think Jordan is eyeballing me, but we have another 3 minutes. If anybody has any questions of our panel? No questions? You guys were really good. All right, then, Jordan, you have a couple of extra minutes.